Welcome to our 10:30 session, which is entitled Property Insurance Coverage, Advocating for the Policyholder. We have two wonderful speakers for this session. Robby Jessup, on my far left, is a serious injury and wrongful death lawyer, and Robby has been recognized as one of the top 40 lawyers under 40 by the National Trial Lawyers. I happen to remember Robby fondly from law school. He was a student when I was there, which means that I am very young and he is very, very young, like a prodigy young, right? Robby is a double Tar Heel, and he operates the firm's serious injury and wrongful death practice. We started talking to Robby after Catherine and I were trying to figure out all of this insurance, and we sat down with Robby over lunch for an hour and learned more than we ever thought we could, both about the field and about our own insurance policy. But after that, Robby has been working really closely with a lot of the legal aid attorneys, and so we're very grateful for him being here. Rebecca Huffman Ugolick. Rebecca's also an attorney with Howard Stallings, and she is a West Virginia University graduate and earned her law degree from North Carolina Central. Her primary practice is in the area of civil litigation, and so I'm going to pass it off to Robby and Rebecca. So, thank you.
Good morning, folks. I want this to be as interactive as possible, so at any point along the way, if you have a question about something, please don't hesitate to stop me, raise your hand. Happy to stop and talk about whatever would be helpful for you guys. Over the past few storms, Becca and I have done more and more work with not only businesses but homeowners who are having trouble with insurance companies that, for lack of a better word, are sometimes behaving badly. I think you see that a lot after a storm. Reason being, if you think about how insurance companies make their profits, they get paid premium dollars, right? And however many of those premium dollars they don't have to pay out on claims is money in the bank, money they can pay their CEOs, in some cases money that can go to their shareholders. So there's some interesting books written about that, and I think it's something probably all you guys have heard of or seen. There's Delay, Deny, Defend. You got a picture of a house burning down with the insurance adjuster leaning in with the policy to burn the policy with it. Really good stuff. I tell everybody to read this book, From Good Hands to Boxing Gloves. Book about Allstate, family dealing with a property loss out in the West, and just the way they got completely hosed. So, in the wake of a storm, nearly all low-income homeowners are going to have insurance, a homeowner's insurance policy. Does anybody know why that is? Right, mortgage, right? Every deed of trust by a bank in this state has a requirement that the homeowner maintain insurance, and low-income homeowners usually have a mortgage. That deed of trust, the way it's usually done, as most of you probably know, is escrowed through the bank and mortgage payments, and the bank makes darn sure that there is a homeowner's policy protecting their collateral. So it's always there. One thing a lot of people overlook is in those deeds of trust, the mortgage companies also have rights to the proceeds, to insurance proceeds. So up front, when you're helping somebody and you get their policy, assuming they have a mortgage, you're going to see their mortgage company listed as a co-insured. The insurance company, for that reason, is going to want to put the mortgage company on all the checks, and you're going to have to be working with the mortgage company to figure out what the homeowner gets versus what the mortgage company gets. Insurance is not legally required, homeowners insurance, but for that reason, most folks do have it. In terms of who the insurers are, I think a lot of disaster areas, your traditional companies don't write coverage. Instead, we have NCJUA. It's essentially NCIUA. They're joint risk pools for people in high-risk areas, but a lot of times those claims are administered by your typical run-of-the-mill insurers. If you're away from one of those high-risk areas, you're usually dealing with State Farm, Farm Bureau, the folks you usually see writing policies in this state. Before I go into the PowerPoint, I guess I'm still on the first slide, I think it's important to talk about the players that you see following natural disasters, or really in any kind of insurance claim, the players that are there and who they are and whose interests they're looking out for. And I'm going to start this with the assumption that you guys know nothing, which I know that's not the case, but I'm going to build off of that. Agents and adjusters. So what's the difference between an agent and an adjuster, right? An agent is the person who has sold the policyholder the policy. And because they were the person to sell the policy and feel some type of customer service duties, loyalty to their customer, they really are usually trying to help. And there are folks you can call to set up a claim, to assist you with the claim, to get it going, to get the process going. They can be good resources. You can also get them to talk to the adjusters, depending on the circumstances. Sometimes they are directly employed by the insurance company. A lot of Allstate agents are directly employed by Allstate. Other times they're independent agents, and they sell for a lot of different companies. But you can really get them to work with you and try to be an advocate for your client in the early parts of a claim. Adjusters. There's lots of kinds of adjusters when we're talking about the property insurance world. You've got desk adjusters. You've got independent adjusters. You've got public adjusters. And I think it's important to understand who these people are and what they're doing and what the difference is between them. And we'll talk more about this in a minute when we get into the PowerPoint slides. But the way it works in the context of natural disasters, what you usually see is, well, the insurance companies have a whole lot of work, right? There's a whole bunch of people that are having losses. It's a lot higher than normal. And the insurance companies don't have the adjusters on staff to deal with all the losses they're dealing with. So how do they handle that? Well, they usually hire independent adjusters, contract out folks to go out into the field, look at the losses, and they're reporting back to people at the insurance company's home offices. And folks we refer to as desk adjusters. Public adjusters, and I think this is a good tidbit for helping folks with low income who don't have a lot of money to pay for stuff. And let me first issue a little warning on that. Public adjusters are regulated by the state. They're licensed by the state. They're in most states. And they're folks that are hired to represent policyholders. And they usually work on a contingency fee, usually something like 10% of what they recover on a loss. And what they will do is they'll oftentimes advance money for engineers if needed, contractors if needed. So if you have a homeowner who doesn't have money to, pay for an engineer or pay for, somebody to come in and do an exact made estimate, which we'll get to later, they're really good folks that you can hire to get them to bear some of that cost for these low-income homeowners. There are some bad public adjusters out there. There are some that are opportunistic after a storm, not responsive, disappear. However, there are some folks out there who are real professionals, who I think are really great folks to get involved and can really benefit insureds, policyholders. Particularly, they're going to charge a contingency fee that's a lot less than an attorney if they end up going with the private attorney, and can a lot of times get claims resolved without the need for litigation and a whole bunch of additional expenses, and you've got them fronting some of the costs. So I think they're important folks to keep in mind. You got the insurance companies, adjusters, the independent adjusters, and then you've got these public adjusters on the other side that you can get to work for homeowners. Other players that are really important in the post-loss world, forensic engineers. Everything's not covered by homeowners policies, as we'll talk about in a little bit. And a lot of times insurance companies will deny claims, saying that the cause of this loss was not a covered loss. Katrina examples. After Katrina, there were homes that were completely destroyed, and there were debates as to whether or not those homes were destroyed by flood or wind. Interestingly, right, because homeowners insurance doesn't usually cover flood. Flood's an additional policy you have to buy. And there's some interesting cases of folks who've climbed up, who were there, stayed in the storm when they probably shouldn't have, and were up on telephone poles or up in trees, and were able to testify as to whether or not the house was blown down first or whether or not a flood came in and took the house down. But absent those folks, the people you need to figure that kind of thing out are forensic engineers. And they're folks that, if you've got an insurance company that's denying a claim, saying not a covered loss, you can hire a forensic engineer to come in and do a report and figure out whether or not it was a covered loss and give that to the insurance company, or testify for you later if it goes to court as to what the cause of the loss was and whether or not it should be covered. This is a game a lot of insurance companies play after losses about, what caused the loss, and we'll talk more about that in a little bit. Lastly is contractors, right? And the contractors are the folks who give estimates, and they oftentimes do the work. All of them don't do the work. Some of them say they'll do the work for some low amount and then won't actually do it. But contractors are an interesting thing, becoming more and more interesting players after large natural disasters in North Carolina. They're doing these things called AOBs now, Assignment of Benefits, and I don't know how anybody familiar with assignments of benefits? Okay, well, they are coming in and they're getting insureds up front to assign their insurance claims to the contractor. And then the contractor goes ahead and does the work and tries to deal with the insurance company themselves and get the money, and they technically own the claim for breach of contract, although they don't own the other legal claims that might be pertinent to the loss. They are able to get the breach of contract claim assigned to them in North Carolina. And the benefit of that to homeowners is that they go ahead and get the work done without having to deal with their insurance company, usually without having to come out of pocket anything, and the contractor will go ahead and do the work. Problems arise, and we've seen a decent bit of this when the contractors don't actually do the work, or sometimes contractors try to inflate the amount of work they did to the insurance company, and additional disputes and litigation arise. But we'll talk more about that in a minute, but I think that kind of covers the players that we're going to be talking about today. Really, agents, adjusters, public adjusters, forensic engineers, contractors. Any questions about any of that? Okay. Well, let's talk about what insurance is. Insurance, in its essence, insurance law is contract law, right? An insurance policy is simply a contract that someone buys from an insurance company, and they pay premiums, and in exchange, the insurance company promises that in the event of the loss, they will provide coverage, right? They'll come in and pay for the loss. It is an indemnity contract, and what that means, and I've quoted some case law here from an Eighth Circuit case, which I think does a pretty good job of defining an indemnity contract. But the basic premise of traditional property insurance is the concept of indemnity. The insured who suffers a covered loss is entitled to receive full, but not more than full, value for the loss suffered, to be made whole, but not be put in a better position than before the loss. So in essence, the basic concept of an indemnity contract is you're putting somebody back into the position that they were in immediately before the loss. They don't get to profit, right? But they're not worse off either. It's to put them back in that same position. Depending on the type of policy you have, you can buy policies that technically do put you in better positions after a loss. But that's a separate issue for now. But I think that is the basics of what you need to understand with regards to what an insurance policy is and what it does. With regards to duties in an insurance policy, the contractual promises that the insured and the insurer are making to each other. An important caveat is that there is more required of the insured, the homeowner under that policy, than simply paying the premiums. There's a whole section titled Duties in the Event of the Loss. And the insured has to do certain things to make sure the insurer continues to hold up their side of the bargain. Those things usually include mitigating your damage, right? That's the biggest one. The insured has to make sure things don't get worse after the loss. They have to do everything they reasonably can to, keep more water from getting into their home or to prevent mold, to do anything they can to not make things worse than what's already happened. The insured has a duty to timely notify the insurance company after a loss, right? An insurance company can deny a claim because you wait too long to tell them about it. There's duties to sit for what's called an EUO, an examination under oath. That's where the insurance company has an opportunity to put an insured under oath and ask them questions about the loss to figure out whether it is or is not covered. You see them do that a lot after storms. They have lots of other things they can require from the insured documents. There's things called proofs of loss they can require the insured to submit, which is always in the insured's benefit to submit, which we'll talk more about in a moment. But I think it's important here, and I'm not sure that's anywhere else in the PowerPoint, to note that the insured's duties and what they have to do for coverage goes beyond just paying a premium. And I think that's an important caveat to add in here. In terms of what we're going to cover from here on out, kind of go over the basics of homeowners insurance policies, types of homeowners insurance policies. All homeowners insurance policies in this state are on forms approved and written by the North Carolina Department of Insurance. But they vary in type, and those types vary in what there is or isn't coverage for. So we'll talk a little bit about that. We'll talk about the claims process, how to move forward in the event of a loss, and potential claims against the insurance company, which I think most folks find the most interesting. Claims for bad faith, unfair claims handling. Anybody have any experience pursuing those claims or bringing those claims? Yeah, we'll talk a lot about that then. So, in terms of what a homeowner's policy is. It's a multi-peril policy, which means there's both casualty and property insurance there. Can anybody tell me the difference between property and casualty insurance? So casualty insurance is really the liability coverages, and property insurance is, the stuff. Liability coverage, if somebody falls and gets hurt on your property, that kind of thing. We're not going to be talking about that so much, but you do see liability coverage on homeowners policies, most homeowners policies in this state, apart from the HO1 and a couple other forms. You usually have on there med pay. It's no fault coverage that'll just pay somebody's medical bills if they get hurt on your property. And then you have liability coverage where if you end up being liable to somebody, that policy is going to pay to protect you and prevent a judgment against you, hopefully. But property coverage is what we're focusing on. And in terms of property coverage, really we've got, they're designated by letters in most policies. And we've got what we call coverage A, which is usually for the dwelling, coverage B, which is usually for other structures, coverage C, personal property, and coverage D, loss of use. See, there we go. That's how you oftentimes hear adjusters referring to it after a loss and people in insurance talking about it by coverage letters. In terms of the dwelling's pretty self-explanatory. It's going to have coverage to fix the property, right? Fixtures, plumbing, heating, AC units, electrical wiring, construction, rebuilding, putting a new roof on the place. I mean, pretty self-explanatory stuff. Coverage B, other structures, the structures not attached to the home but that are on the property. Same sort of thing. Coverage C is personal property. It's the property in the house that gets destroyed by the storm. And, jewelry, clothing, memorabilia. And when you're talking to folks, it really is important that they photograph this stuff before a storm and that they keep some type of inventory of what they do and don't have. Because they're going to have to show that to the insurance company after a storm if they lose that stuff. So it's highly important to photograph and keep up with those things prior to a storm taking place. In terms of what's there to immediately help the folks right after a storm hits, that's really the loss of use. And the term that you'll see in the policies, a lot of policies, additional living expenses, what you'll hear referred to as ALE. And that's money to help those folks with meals, with housing, with anything they might need for daily living when they've been displaced from their home as a result of a loss following a storm. And, adjusters are usually pretty good about providing that stuff up front early on in the loss. I mean, they want to keep you happy, or maybe you take a little bit less on the other end of this thing. And they usually up front will try to provide those things, and they have a legal duty to. But of course, your insured needs to keep up with receipts, provide receipts, talk to the adjuster about housing, where they're going to go, the price of housing. It's some money that's there for immediate help. We'll skip over that. In terms of what homeowners insurance doesn't cover, and we've already said floods, but it also doesn't, your standard homeowners insurance cover earthquakes, mudslides, landslides, terrorism, the apocalypse. It's not going to provide coverage for those things. So, in terms of flood insurance, if folks live in a high-risk area and they have a mortgage, if they live in a high-risk area for floods, much like regular homeowners insurance, and I'll tell you up front, we don't do a whole lot with flood insurance. We're more lawyers that work on the other side of it. But with flood insurance, a lot of times lenders will require people in high-risk flood zones to carry flood insurance, and for that reason you might come across a lot of folks that have it after a storm. There's really two types that are out there. There's private flood insurance and the National Flood Insurance Program. There are waiting periods for flood insurance, which I've seen folks who weren't aware of that, and it's caused them to suffer non-covered losses. I had some folks call me in New Bern after this last hurricane, and they had just bought the house like 5 days before and just had the policy written. But because there was a waiting period and their house flooded, even though they had a policy for flood, there wasn't any coverage because the waiting period hadn't run. So you can't just go out and buy flood insurance when you see the storm coming. It's something you have to buy ahead of time because there are usually 30-day waiting periods. The data numbers can differ, but it's an important thing to keep in mind when you're advising folks about this kind of stuff. And this is an important note, a lot of homeowners think they have flood insurance when they don't. A lot of people think that homeowners insurance covers flood. Not the case, and it's important for folks to know that. These are some facts. I don't think it's real important to talk over those right now, but those are some stats from the NCIUA and NCJUA risk pools down at the bottom that we were mentioning earlier. Types of homeowners policies in North Carolina. I'm going to have Becca quickly talk over the types of policies and what they do and don't cover, and then I'm going to come back and talk a little bit more about some claims handling aspects.
As Robby mentioned, really the policies are contracts, and most people don't understand what their policy entails. Ignorantly, I didn't really know when I started receiving all of these claims. I didn't even know, what type of policy I had. So it's really important that just right out the bat you understand what you're dealing with and what type of policy that your client has. There are certainly, I think there are 8 types, and the most common though, and what I see every day is the H03 policy. And like Robby said, these insurance adjusters, every day they use these abbreviations, so they'll come to you, and when I first started practicing, they're like, oh yeah, the H3 policy, and I didn't know what that meant. But they talk in this language where, it's like ALE, and, they're talking about all these things that they just assume and so it's always good practice to get a copy of the policy. Now, the most basic form is the HO1 policy, and it protects against damage from fire, hail, basically vandalism, and any type of theft. However, the thing that is not covered by the HO1 policy is any type of liability, like if someone is injured on your property. But an important thing to always check for is if any supplemental coverage exists, like flood insurance policy. Now, the broad form HO2, that is, I don't see this one very often. It's for single-family dwellings or townhomes, and the perils are specifically kind of outlined within the policy. So that's why it's important to get a copy to see what is covered, because more often than not, people really don't know what is covered. Now, with HO3, that's what you're going to see most often, and that's an open peril policy. It just basically provides for any direct physical damage that is named within the contract. And what is important to note about this, like Robby said, and not to beat a dead horse, but people have this HO3 policy and they think that floods are covered under this policy, but they're not. So with the HO4, this is what you're going to see when you encounter renters. And so with the HO4, you get essentially the same coverage as the HO3. It's just on a rental basis. and it provides for personal liability and also for property protection. And we'll I'll go through that in a few minutes in talking about inventories and the importance of those, because as you can imagine, when somebody is going through some type of natural disaster, the last thing they're going to want to think about is, hey, do I have a photograph of all of my contents in my house or an inventory of all of my contents? And that's really frustrating when you've been through some type of natural disaster to recognize that, hey, your insurance company is going to want a list of everything in your house, from the age, the type, the style, before you can get any compensation for losing those items. And with the HO5 policy, it's the same as the HO3, but it also protects belongings. It's kind of like the red carpet insurance. I don't see that quite really ever. But with the HO6, that's what you'll see. Like if you have a condo situation, there's some type of damage due to a natural disaster. Let's see what's next. Robby's going to talk to you next about the claims process and going through proof of loss, and I'll come back up and kind of explain inventories and some of the struggles that I faced recently in trying to help folks put together inventories and the importance of that.
All right, so I think we're tight on time, and I want to spend a good bit of time on the bad faith stuff, so I'm going to move through this a little bit quickly. In terms of the claims process, really what I'm going to talk about here is things that I think people are calling you with that they're having trouble with, and ways to address their problems. First thing, I hear from a lot of lawyers and a lot of people, they've got somebody on the phone and they say the insurance company is just not responding, right? They're just not getting back to me. They're not paying my claim. They're ignoring my claim. A proof of loss is a way to speed them up. It's a creature created in the policies, and there are state regulations, Department of Insurance regulations, that compel insurance companies to respond in a somewhat timely manner when they receive these documents. So what is a proof of loss? I'm not going to read all this, it's essentially an affidavit. It's a notarized statement by an insured saying, I sustained a covered loss, and if you can attach to it an estimate and an inventory for contents, you can put pressure on the insurance company to go ahead and pay those things. They're very simple forms that can go a long ways. This is an example of one, and then you attach the estimate to it and you attach the inventory to it. In terms of estimates, a phrase you often hear insurance companies use when they're talking to you about estimates after a loss is they're referring to Xactimate, spelled Xactimate. Anybody ever heard that phrase? A lot of you? Okay. An Xactimate estimate is essentially a software that does these estimates. And it's what's used across all insurance companies, and it's really a line item type of estimating software, and it's what they give the most credence to. Instead of just having your local Joe Blow contractor writing down a number and saying this is what I'm going to do, it justifies it, and it by zip code categorizes the cost of things and says what something should cost in your market, where everybody knows they're not being ripped off, right? And any contractor really worth their salt that you want working with your insured after a loss should have Xactimate software and should be able to produce an Xactimate estimate. If your insured's working with somebody who doesn't have that, it's probably somebody you don't really want to be dealing with following a loss, because it makes it harder to get their estimates paid. Their estimates don't have as much credence with the insurance company. So if you really want to put the pressure on an insurance company to pay, you attach to your proof of loss an Xactimate estimate from a contractor who will do the work. And it also makes it easier when you're arguing with the insurance company over their estimate, because they're also using this software to compare the line items and the two Xactimate estimates and say, this is where your guy's wrong, this is where my guy's right, or this is where the adjuster was wrong, this is where the other guy's right. So it's a way to sort of force that issue. In terms of, and also I think it's important to know, and I think I said this earlier, in the duties after a loss, oftentimes there is a duty for the insured to provide a proof of loss. And it's oftentimes required in the policy, and insurers can require them. I'll touch on this real quick. This is, I think this one's from State Farm.
It's from State Farm, yeah.
Okay. This is, when I talk about an inventory is for contents, when you're talking about attaching an inventory to a proof of loss. What you put on there is essentially the items that were lost, and the insurance company has some things they want to know about those items. They want to know how old the items are, and they want to know whether or not you've replaced them yet, and if you have replaced them, they want the receipts. And the reason for that being ACV versus RCV. Can anybody tell me what that means? Right. So the way most policies in this state read is that at the time of the loss, you can go ahead and get the ACV, essentially the depreciated value of the item. And the insurance company has to come up with that, so they need to know the age of the item, some other information about it. There's lots of ways to argue about how you should calculate ACV. That's not an easy conversation to have, and we can talk about that for hours. But in terms of doing the inventory, you put, the age, and then if you've replaced it, you give them the receipt. Once they get the receipt, you've actually replaced it. They usually owe you the replacement cost value. And it's the easiest way to get these things paid is to put all this stuff down and attach them to a sworn proof of loss. And that's a little bit about what I was just talking about. ACV and RCV also sometimes applies in the context of dwelling coverage, other coverages, but I think in terms of what I hear from most folks who are sort of frontline people dealing with it, you usually want to know about it in the context of an inventory and figuring that stuff out. We've talked about that. Appraisal. So if you've got somebody that calls you and says, I lost my roof in the storm, and the insurance company says they'll only pay me $5,000 to replace my roof because that's all it cost. And they say, my contractor says I need at least $15,000 to replace my roof. Appraisal is something you can do short of filing a lawsuit. It's something that sometimes, and I'll add the caveat, sometimes, depending on who your appraisers and umpires are, can be a much cheaper and shorter process of resolving a dispute with an insurance company as to the amount of loss. The way appraisal clauses read in the North Carolina fire policies, it says if you and we disagree on the amount of loss, right? Appraisal is essentially an arbitration that can determine the amount of a loss and have a binding result. What appraisal can't determine, coverage, it can't decide whether or not something is or isn't a covered loss. It can't determine the scope in terms of, the amount of damage that should or shouldn't be covered. But what it can do is if you have a dispute with an insurance company as to the amount of the loss, you can invoke the appraisal process. And appraisers, the way that works is each side appoints, it's sort of like a UIM arbitration. Anybody have much experience with that? It's each side will appoint their arbitrator, essentially, their appraiser. And those two appraisers will come up and agree on a neutral, the third person. And the third person is really the decision maker. And the appraisers and the neutral get together and, appraiser for the insured will usually say, this is the estimate my person has, this is how much it's going to take to fix this roof. The appraiser for the insurance company will say, no, this is how much it'll take to fix the roof. And then the umpire will usually agree with one of them or come to some decision that all three of them can sign off on. But it takes two of them to render an award. If they can't agree on the umpire, you can go to court and get an umpire appointed by the court, somebody fair. I like to see building inspectors, prior judges, mediators, contractors even, make good umpires. But if you're helping a policyholder, you need to be weary of umpires suggested by the insurance company to make sure it's not somebody that's just going to always give the insurance company what they want. You need to make sure you're getting an actually fair panel. And if you have an actually fair panel, I think this is a really good way to cheaply and quickly resolve a dispute with a binding result as to the amount of loss following a disaster. Any questions about appraisal? Okay. We talked about contractors, Xactimate, assignment of benefits. We've talked a little bit about forensic engineers. And again, I mentioned that you can oftentimes, if you can find a good public adjuster, get them to front the money for these kinds of things for low-income people. But let's talk about claims against the insurance company, really what your leverage is in getting the insurance companies to do the right thing. And there are really essentially four kinds of legal claims that a homeowner might have following a disaster, depending upon how their claim's been handled against an insurance company. And those are declaratory judgment actions, breach of contract, bad faith, and unfair and deceptive trade practices. In terms of declaratory judgment actions, I'm sure you all remember this from law school. If there's actual dispute between people on something, you can go to the court and ask the court to declare the rights of the parties. You can go to the court and ask the court to find whether or not there's insurance coverage for something. And that is a type of claim you can bring. You can bring the claim to the court and say, is there insurance coverage for this or not? And insurance companies sometimes file these kinds of actions as well. You also have breach of contract. Again, the essence of insurance law is contract law, and insurance policy is a contract. And if the insurance company doesn't do what they're supposed to do under that contract, you can sue them for breach of contract, which usually being in terms of damages is the amount owed under the policy. Some states like Florida and some others will give, attorney's fees, things beyond the contract just for proving breach of contract. In this state, you just get the actual amounts due under the policy. And then the more fun ones to talk about are bad faith, which essentially not acting in good faith. In every contract, there is implied and read into it a covenant of good faith and fair dealing. And when an insurance company doesn't act in good faith, they can be sued for bad faith. In terms of, anybody ever read Rules of the Road? It's a really good book. It tells you sort of how to formulate rules for proving liability in a courtroom. And in it, they come up with certain rules for handling certain kinds of cases and tell you how to come up with your rules for handling your own cases. Just real clear statements of what is or isn't proper behavior. And in that, and really first few chapters, they have a list of, conduct that an insurance company has to comply with, and if they don't, then they're acting in bad faith. And I think as opposed to reading you a bunch of case law, just reading you some things from this list might give you an idea of what is or isn't bad faith. The list I'm reading, I've somehow lost my book. We looked for it yesterday. It's a list that's been reworked a little bit by Chip Merlin of the Merlin Law Group. He does a lot of property insurance stuff, but I'm not going to read all of it. But if an insurance company is not doing any of these things, then I think you can start to consider bringing a claim for bad faith. And with that claim, beyond the contract damages, you can get punitive damages. And you start to get really big damages to really punish an insurance company for bad conduct. But just to read a couple things from this list. An insurance company must treat its policyholders' interests with equal regard as it does its own interest. The claims process is not supposed to be an adversarial process. An insurance company must assist the policyholder with their claim. An insurance company must disclose to its insureds all benefits, coverage, and time limits that may apply to a claim. So if an insurance company is misrepresenting coverage, not helping the policyholder, not informing them of what's going on with their claim, you start to get into the world of bad faith. An insurance company must conduct a full, fair, and prompt investigation of a claim at its own expense. Right? The insurance company shouldn't just be denying claims without an investigation and shift the whole burden of proving a claim on an insured. That's not how this is supposed to work. Insurance company must fully, fairly, and promptly evaluate and adjust a claim. An insurance company cannot deny a claim or any part of a claim based on insufficient information, speculation, or biased information. And just to bounce around a little bit in the interest of time, one I really like is an insurance company cannot act with a profit motive in the claims handling process. And legally they should not. And if you can prove they are, which we all know what's going on oftentimes, you really get into the world of bad faith. What an adjuster is supposed to be doing is coming up with what the insurance company owes on a claim. They're not supposed to be saving the insurance company money. That's not what they're supposed to be doing in the claims handling process. And if you catch them doing otherwise, this is something where you can really get some leverage. This list goes on. You can read the whole thing in Rules of the Road. If you hadn't read that book and you do any kind of plaintiff's work, I highly recommend that book regardless. But it's a good list there, and goes on for about 10 times the number of things I read. The other claim we have, and this can get folded back into bad faith, what I'm about to talk about, but let me separate it out for a minute. In North Carolina, we have bad faith as a common law creature, right? It's something that exists in most states. We have another claim that we call unfair claims handling, which is really a Chapter 75 claim brought under our Unfair and Deceptive Trade Practices Act. And the benefit of this claim is it's got a lot, in ways it has a lot more teeth than a bad faith claim. With this, if you can prove an unfair claims practices claim, you get treble damages. You get triple the damages. It's automatic. There's no question. The judge can't say, oh no, I'm finding, you prevailed on this claim, but I'm only giving you 2 times the damage. You get automatically 3 times the damage, and you automatically get attorney's fees. And the way this claim was created, it's a case I've included in the materials. I think it's included in the materials.
It is.
That were provided to you. And essentially, our case law developed to say, if you violate any of these things in our insurance regulations here in Chapter 58, there's a list of things, conduct that is prohibited under Chapter 58. That's our regulatory section on insurance. And it says if an insurance company does any of these things, it has engaged in an unfair and deceptive trade practice in violation of Chapter 75, getting you to treble damages and attorney's fees and all that stuff. And the first real case about it was Gray. There's subsequent case law that developed to incorporate really the whole list. But in terms of that conduct, the list that I'm referring to, it's here in NCGS 58-63-1511. And just to read from some of the most relevant of those, A, misrepresenting pertinent facts or insurance policy provisions relating to coverages at issue. If an insurance adjuster misrepresents what coverage there is or isn't to an insured, that's a unfair claims practice where you can get treble damages. Failing to acknowledge and act reasonably promptly upon communications with respect to claims arising under insurance policies. C, failing to adopt and implement reasonable standards for the prompt investigation of claims. D, refusing to pay claims without conducting a reasonable investigation based upon all available information. E, failing to affirm or deny coverage of claims within a reasonable time after proof of loss statements have been completed. Again, getting back to the importance of those proofs of loss. You can, if they don't get back to you, they don't do what they're supposed to do. Once you've given them proof of loss with those things, you've got a pretty good unfair claims handling claim, and you've suddenly got triple damages and attorney's fees. So again, getting back to the importance of submitting proofs of loss. Not attempting in good faith to effectuate prompt, fair, and equitable settlements of claims in which liability has become clear. This is a big one. Compelling the insured to essentially file a lawsuit to recover amounts due under an insurance policy, by not offering enough money. That happens all the time, and that is an unfair claims practice. Attempting to settle a claim for less than the amount to which a reasonable man would have believed he was entitled. Attempting to settle claims on the basis of an application which was altered without notice. Making claim payments to insureds or beneficiaries not accompanied by a statement setting forth the coverage under which payments are being made. And that's a big one. You see a lot of times after storms, these insurance companies are overwhelmed and they're just writing checks. But they need to be paying attention to what they're doing. You a lot of times see advancements or payments made and they don't tell you what coverages they're paying under, and then they come back later and try to use the prior payment and say, oh no, it went under this coverage, so we're reaching the cap. And that's something to watch out for and something they shouldn't be doing. Delaying investigations, delaying payments of claims, failing to promptly settle claims, failing to promptly provide a reasonable explanation of the basis in the insurance policy in relations to the facts or applicable law for denial of a claim or for the offer of a compromised settlement. When you're insureds, when you're helping these folks after storms and they're getting denial letters, those denial letters can't just say, we're denying your claim because we feel like it. They have to put in those denial letters the basis for the denial, the policy provision under which the denial is being based, and the facts that support that denial. Otherwise, they're in violation of this statute. And a good way to try to help folks is if you get one of those blanket denial letters, which are all too common following big losses across the state, call up the adjuster, write the adjuster, ask them, say, look, this law requires you to explain why you're denying this claim. What's the policy provision? What's your basis? Push them to put that stuff in writing, because if it heads to litigation, it will be important later. So I've got, according to my watch, 3 minutes left. Yes, ma'am.
Something we ran into a lot in a hurricane setting is that damage would come in due to wind and trees through the roof, the side, as well as due to flooding through the bottom, and insurers would, of course, claim that flooding is the cause or a cause, and the flood insurance policies have so much less benefits, alternate way and all that sort of thing. And from what we were looking at, there were these anti-concurrent causation clauses, where in some states it appears that if there are concurrent causes, both are covered. It appears in North Carolina, as far as we could tell, that if there are concurrent causes but an anti-concurrent causation clause, they can do that. That they can say flooding caused your damage, go to FEMA. Have you had that issue come up?
Yes, ma'am. Yes, ma'am. we get back to the forensic engineers and looking at that stuff. You can almost always parse out what's flood and what's wind if you look at it right and nip those arguments in the bud. I take issue with the concept of that argument to begin with, but I hear it a lot from insurance adjusters. Really, what it sounds like you need there is forensic engineer to come in and parse out what's flood and what's wind, and to break that out and say, okay, this is what's owed by the flood, this is what's owed by the homeowner's insurance, and if that doesn't get you anywhere, sue them both. Yes, sir. I know nothing about that. Tell me a little bit about what that is.
The last couple of hurricanes, the last 3 hurricanes, the Department of Insurance issued a disaster mediation program that requires notice on all claim forms to go to the insurers saying they have the right to mediate. It's paid through AAA. Our firm does 3 counties we mediate in Hampton, Brunswick. We've done about 150 mediations for the last year.
Okay.
About 75% of the stuff they mediation.
Is that just with NCJUA or NCIUA stuff?
Every claim filed with homeowners under the homeowners policies in those counties that declare disaster.
Okay, in those disaster areas. Okay. Well, that sounds like an excellent program. Usually I'm the last person who sees one of these cases, and usually I'm at the point of filing suit, and I don't have a lot of experience with that stuff early on, but I think,
Look at the Department of Insurance website, there's a disaster mediation link. And if you get a claim, you have 60 days from the last payment to file for mediation. It's paid for by the insurance carrier. So it's free to the homeowner.
okay,
They get 2 hours with a certified mediator. Most cases end up settling.
really?
Yes.
Okay, that's wonderful. That's wonderful. And it applies to all types of losses, flood and homeowners policies.
All homeowners and HO and DP policies.
Okay, wonderful, wonderful. Well, that's something really good to keep in mind if you're practicing in one of those affected counties or counties where that applies. Anything else? Yes, ma'am.
Are the insurance companies required to know what the property is damaged or storm to bring that to code? I've heard that folks think that they're denied coverage to bring their home up to code, say it was electrical and it's not within the current codes, and they're denied those benefits.
There's usually coverage in policies for code upgrades, and you need to look at the policies to make sure that's there, but that is in most policies. There's a separate breakout amount of money for code upgrades. Any other questions? I think I'm over my time, so I enjoyed meeting all of you, and wish you luck, and thank you for your time today.